Please, let's listen to her. All right, thank you very much. Please clap for her. Then who else wants to give us a summary? You want to try? Who else? Okay. The ladies are the ones that are active in this class. Okay.
About street issues. And we talked about models to go about some issues, and they said you have to dramatize it. And they said you have to work and way to keep that. I want to talk about negotiation because it says that in negotiation the two parties really come together to cooperate, to compromise, and to make a concession.
Consensus. Yeah.
To amicably solve the issues between themselves, and they said the negotiation between the third party, the third party have to be involved in the issues to make sure you manage the situation.
All right, please come for her. That's another good one. I need a man now, so that at least you don't put me to shame in this class. I need a man. Where is the man that wants to rescue? No man. I need a man to give us a summary of what we did in our last class. Where are they? Okay, that's the only man in this class. Please clap for him before he even makes a submission. You can imagine when people have to deny their agenda because they don't have an answer. Please speak into the mic so that we can hear you. All right. Thank you very much. At least I was not put to shame. That was a good one. At least it's just to show our level of understanding as to what we are teaching you. And like I always say, when you attempt such questions in class, it gives you an opportunity to learn, because whatever you say, it may be difficult for you to forget. So, having said that, we stopped somewhere around the African traditional method of conflict resolution. Am I correct? Where we've looked at negotiation method, and mediation method. So today we will continue in that same manner to look at the third method, which is known as arbitration method. You have a question? What? Yes. No. There was no need for that. Okay. All right. So we talk about the arbitration method. And the first question we need to ask is, what is arbitration? I'm very sure that we're not hearing this word for the first time. Okay? So what do you understand by arbitration? You can't remember? Yes, my friend. You don't know what arbitration is? Yes. Engineer. So what is arbitration?
Power to determine the course of action for a decision.
Okay. That was a kind of technical definition, which is okay. But when you hear the word arbitration, of course, what comes to your mind too is something that has to do with dispute management. Now, arbitration can simply be defined as the enabling will and power to decide and determine a course of action. I'll repeat that. Arbitration can simply be defined as the enabling will and power to determine, to decide and determine a course of action quite instrumentable to decision making. Arbitration can be simply defined as the enabling will and power to decide and determine a course of action quite instrumentable to decision making. So when we look at it again, it simply tells us the idea, present an idea of reaching out in any dispute situation where parties can have like a form of amicable settlement that is different from what we can talk about under litigation. So, and like we said, the purpose is to address the concerns of the parties involved in such a dispute. So therefore, arbitration has been one of the significant methods of resolving conflicts in the traditional African society. As a matter of fact, it involves different parties, which include the arbiter, who is the judge in this case. Let me use the word judge, but the judge in an arbitration proceedings is referred to as an arbiter. Arbiter is spelled ARBITER. Okay? And of course, we have party A or party B or party C, as the case may be. But what we are saying in essence is that under the arbitration method, there is an individual known as the arbiter who serves as the judge. And of course, when you take your mind back to when we're talking about negotiation or mediation, we did say that there is someone in between the two parties who mediates, who helps them to have a compromise or facilitate cooperation between parties to the extent of having a consensus among the two of them. But the individual who plays this role under the arbitration method is referred to as the arbiter. And of course, the arbiter being, a very important figure in the dispute resolution case, is expected to understand the intricacies or everything that surrounds the dispute between the parties. Of course, if he doesn't know the issues that are involved, it will be difficult to do justice as the occasion will demand. So he is expected to understand and also to reach a special decision which will be beneficial to the parties involved. Of course, the goal of arbitration is for parties to amicably resolve whatever the dispute may be. Okay? So, he also facilitates the submission of parties to the arbitral proceedings. He does what? He facilitates the availability and cooperation of the parties. Because if the parties are not willing to sit down at the table, then how then do we address the issues? So apart from the fact that it's duty bound to understand the duties or the facts of the case in issue, he also has a duty to bring out a judgment or a decision that is fair enough. And again, we have established that he also has a duty to facilitate cooperation between the parties that are involved so that they can submit willingly to the sessions that will probably be held between them. So, at the same time, also, he also provides for the venue where such decisions will be taken and executed. Okay? So, one of the things you will have noticed in the case of the arbitration method is that there are some specific duties that we have identified that the arbiter needs to perform. Are you following me, class? The first one is what? You need to understand the fact or the case at hand. Number two, you need to also enable them to have to submit to the proceeding. Number three, I didn't get that. Okay, we need to arrive at a decision at the end of the day. Yes. Okay, it needs to also make venue available. So all of those roles are central to what the arbiter needs to do. And in doing all of this, he needs to, put into consideration, or what should guide his action will be justice. Let's say, for example, Mrs. B is a party to a dispute where I'm the arbiter. Mrs. A here is also a party. Mrs. B lives in Port Harcourt while Mrs. A lives in Lagos. And then, if the arbiter now decides that the sessions must hold in Lagos, will it be fair to the one residing in Port Harcourt? So, issues as simple as determination of venue are crucial, or is crucial in the case of the arbitral proceedings. So, what the arbiter needs to ensure is that the venue selection must be the type that will favor the party. As a matter of fact, if at the stage of selection of venue or trying to determine where the proceedings will take place, it's not fair to one person. The individual is already, will definitely become apprehensive to think that if they can choose the venue without putting me into consideration, how am I sure that whatever decision that is reached will be favorable? So one of the things you will have noticed is that will not give the parties the enabling environment to discuss so as to have an amicable resolution of whatever is the issue within the parties. So, apart from all of that, what is the focus of this exercise is that justice is served. So, again, the venue is usually or technically referred to as the arbitral courts. Arbitral courts or tribunal. Arbitral is ARBITRAL. And one of the things that will probably come to our mind as we are speaking is that our focus may have probably shift from a local setting that we are looking at. Of course, what we are dealing with is the indigenous African society. So when you now hear the word arbitral court, arbitral tribunal, as the case may be, you probably think that where did they develop all of that at that early stage? Now, the venue of the arbitral proceedings may even be in a family yard. But as far as the place is considered to mean that, okay, we want to hear the two parties and decide, that particular place will become a court or a tribunal where the parties will sit to arrive at a conclusion. Just like in our contemporary time, the courts can move from their usual court and come and sit here. The courts can leave the usual court. Probably all of you know the Lagos State High Court, right? You know the Lagos High Court at Ikeja. A judge can choose to come and sit here. And then once the court is sitting here, the lawyers are there, those who have complaints or the litigants are here, automatically this place becomes what? A court. Because in legal proceedings, sometimes the judge may have a need to visit the scene of action. Okay? If maybe something has happened, somebody was killed, and then there were a lot of, the court will move from the usual courtroom to sit in that place, probably to examine a lot of things, and then make some decision right there and there within the parties. So, what we are talking about need not appear sophisticated, but it must be able to paint the picture of what it is for people to come together with the aim of resolving a conflict. Now, let's take it forward by looking at the significance of arbitration method in conflict resolution. What is the importance of this particular kind of dispute resolution method? Now, the importance is not far from the fact that the arbitration method has produced great level of trust. Okay? It has produced great level of what? Of trust, confidence, and mutual understanding in traditional African society. Arbitral proceedings have produced great level of trust, confidence, and mutual what? Understanding in traditional African society. Because of all that we have said, that the action or The cause of the action is to ensure that justice is what is achieved. And if you look at what we have talked about, the fact that he needs to provide the venue, he needs to ensure that parties are ready to submit, and then also reach a decision at the end of the day. It brings about a situation where people can trust. And again, one of the things I also need to note is that if we are talking about the quality of the arbiter, that is the man who will serve as the judge, he is usually someone who is familiar with the customs. What? The custom and what? And either the customary law of their particular place in question. If I'm not a man and you call me to preside over a dispute involving the Edo's native law and custom, I will not be able to do or to do justice. Why? Because I cannot give what I don't have. But someone who is grounded in the Edo customary law, we have what? A better place to adjudicate between the parties. So let's just identify the importance one after the other. Number one, it engaged the attention of the sage and the supernatural in African environments. It engaged the attention of the sage, SAGE, and the supernatural in African environments. Number two, significance is that the arbitrator, the one I referred to as arbiter in the first place, can also be referred to as what? The arbitrator. The arbitrator relied heavily on the dictates of the supernatural and tradition. It also what? It relied heavily on the dictates of the supernatural and the tradition. Of course, that includes the customs, the norms, and the culture of the particular people in question. So number three is that the decisions agreed upon must be satisfactory to the parties in conflict. It must be satisfactory to the parties in conflict and must be so popularly acclaimed to the populace. I said the decision agreed upon must be satisfactory to the parties in conflict and must be so popularly acclaimed to the world, to the populace. Now, one of the things that I need to point out as we try to understand this system of dispute resolution is the fact that it may be difficult to please human beings. Do you understand that? I don't believe that you can actually satisfy a man. When I mean a man in this case, I'm talking about man and woman. You understand that when you do something for a man, man is always feeling that you should have done more. And that's why we give a case of the case between Atiku and Obi and Atiku. Okay, it was in this class, but the matter we're discussing relates to this. And we said that when the court gave the judgment that President Tinubu won the election, the other two people will definitely feel that, that wasn't the case. And I'm sure even some of us that we are sitting here, we share similar view that, probably the judgment was not the right one. See the way this woman is laughing, meaning that she's one of those who believe that the judgment was kind of neither here nor there. But to the people who are in the articles camp, we feel, oh, they will say usually the judgment has been what? Has been bought. But to the bad people, Tinubu people, what will they say? It was a fair judgment. As a matter of fact, they will come out and say, we want to congratulate the judiciary for a well-considered judgment. Yes, they will come and say, this is victory for what? For democracy. You know how they watch TV. Eh? Don't you see that when they make such the other party will come and say this is a ridicule of the judicial system of this country. Why? Because they are not what? They are not satisfied. But where we are going is this. You know, when a judgment appears to be genuine and real, the majority in the society tends to do what? To have like a form of agreement. Just like in this country now, things are hard, right? Am I saying what is right or what is wrong? Because the things you buy for like 100,000 like 2 years ago can not be less than 200 now. But some people will come to the television studio to say that we have never had it this good since our independence. That Tinubu's government has been able to stabilize the economy to the extent that the common man are happy. The way you are even reacting shows you are not happy. But if another person comes and say, we've never had it this bad in this country, that the common man cannot feed, that man is likely to have the popular support, isn't it? Because those who come to say otherwise, they are the few that are benefiting from what is going on. So even deep inside of them, they agree with the man that said things are bad. And indeed, things are bad. Those of you that do Brazilian hair and all, you know how much you were buying those things before? Or there's nobody that can buy Brazilian hair here. If you have money, or don't pretend as if you have money. What you used to buy before is no longer the same. So there is a way in society we agree that yes, this judgment was what was fair. So what we are saying is that the outcome of the arbitral proceedings must be seen by the majority of the populace to be what? To be fair. We can have such judgment. Such judgment is the fact that I just gave to you now, that things are not easy with Nigerians. Of course, you probably know some of your family members that have left this country. And some of you that you are here now, if they give you opportunity as we speak now, they said maybe your degree or to Japa, you will not even want to go. You say, let me go from here. Why? Because of the state of things. So what we are saying is that whatever decision is arrived at the traditional arbitral court or tribunal must be the one that has some form of popular support. Okay, so 1, 2, 3, 4. The fourth one is that the decisions were flexible and had human face implementation. The decisions were flexible and had human face implementation. What do we mean by that? Human face. When you put human face to something, the normal human face now, you want me to spell that for you? Human, then face, F-A-C-E, the face, the one in Facebook. Or you don't do Facebook. All right. Now, what we are saying is that You know, there are some decisions that are not, that really do not have human face. What we're talking about having human face is that you try to empathize, you try to understand that this person may not be able to meet this, but let me give him time to do what? To repay. That is an act of, say you put human face to something. Somebody is owing you. Who is owing somebody in this class? Okay, you are owing somebody. What are you owing? That drama queen behind you. So let's say somebody is owing this woman now. Is owing somebody maybe 5 million. Owing this woman. And this woman now said, okay, what are colleagues for? You can do 2 million first and then spread the what? Spread the rest. What she has done is that she has put human face to it. It's different from saying that, I don't agree. You must pay my money today. So what we're saying is that under this dispute resolution interface, the decisions were flexible in that the individuals involved can be given some level of grace before they do what? They probably repay whatever is due for, as decision in that case. So that's what we mean by that. Then number 5 is that the arbitral venue was conducive enough to allow for the interplay of the spiritual elements. The arbitral venue was conducive enough to allow for the interplay of the spiritual elements credited to influencing positive decisions. Credited to influencing positive decisions. Of course, in the traditional setting, you usually believe that the gods have a role to play, and that if the gods do not allow the dispute to be resolved in that way, it may not be possible. So there is this level of we have attributed some level of success to the spiritual or the supernatural, which also we may not be able to run away from in the terms of what we are talking about. Okay. Okay, so just to add to what we have been saying is that the flexible nature of the arbitral proceedings also makes the parties to be satisfied in some ways, because you have said your own, this person has said his own. When you are settling dispute, sometimes you will say, even if the person, if she has said I'm sorry, it will have ended it there. Haven't you seen situations like that? He said, but he was still claiming rights. If he had, but so the thing is that in a normal formal court, you don't see such. You have to follow the rule. Nobody is laughing with one another. But in a traditional setting like this, parties were free to interact, have some form of understanding, and then those decisions, though I would say that the decisions were flexible, that it's not the one that can be so difficult to achieve. Okay, so that's for that. And I must say that the arbitral method or the arbitration method has helped to preserve the African heritage or the African cultural heritage and development. Okay, so that's one significance that we can attach to that method as one of the methods that we are to look at in under this particular topic. Now we move on to the next method, which is the adjudication method. Adjudication method. Adjudication is spelled ADJUDICATION. So what do we mean by adjudication? Adjudication can simply be defined as the process of reaching and concluding decision on issues of conflict. I repeat that again. Adjudication can simply be defined as the process of reaching and concluding decision on issues of conflict. So there is the gods at work now. They've taken over our mic. The gods are at work. Thank God we have an engineer. Yeah, I'm coming. Okay, are we good now? It's also possible they are hearing what we are saying there. Okay. So that means the system you have bought is a cheap one. That's I said adjudication can simply be defined as the process of reaching and concluding decision on issues of what? Of conflicts. Passing judgments on conflicting situation. Adjudication is a systemic approach to pronouncing judgments on conflicting situation. Now, one thing that would have come to your mind by reason of what I've just said is the word judgment and the act of pronouncing judgment. Okay? So unlike the other previous method that we have looked at, the mediation method, the arbitration method, which other one? Negotiation method. The adjudication method comes with a different view of pronouncing judgments. Okay? That this particular fact or this particular aspect of it makes it different from the other method that we have looked at. So this suggests to you that verdicts are anchored on adjudication in order to identify the guilt and innocence of conflicting parties. In the other method that we have looked at, we never discussed that this person is guilty while this one is what? Innocent. So this is a central feature of the adjudication method. Do you understand now? In negotiation, we will not say Mrs. A is wrong, Mrs. B is what? Is innocent. No. The same thing with arbitration method. But when it comes to adjudication method, there is need to identify who is the guilty one and the what? The innocent. You know, in dispute resolution management, sometimes there will be need to do the identification. So when there is need to do that, adjudication method comes into play. But one thing we need to also note is that in the African traditional setup, pronouncing judgment and deciding the guilty party was not like the focus. It's not the focus of traditional dispute resolution. Do you understand? It's not usually like an ideal thing that the system wants. But like I said, at every point in time, there will be need to make such pronouncements. In the case of someone who has stolen another person's property, are they in the same position? No. The one who has stolen should be made to understand what he has done wrong. It's different from him returning what he has stolen and be made to go scot-free. Do you understand the point? It's different from the one who borrowed money from another person and he's saying that I'm not saying I'm not going to pay you your money. I'm going to pay you your money, but I do not have the money now. And then the arbitrator is trying to say, okay, how many months or how many weeks can you give him to pay? It's quite different from someone who has committed thefts. Because for a thief, if a thief is not caught, is deemed to have succeeded, right? Yeah, he will not come back to you tomorrow to say I stole, except maybe the person has met the Lord Jesus Christ. That's when he will not come and do what? And apologize. But a thief will always be happy at his success in every act. It's when you catch them, they will now do as if they cannot do anything. But I know they can do many things. So when I see them, I usually don't have that pity for them. Because I know that if they had done that successfully, they would have been happy. So, this kind of method in the indigenous traditional society helps to handle cases like that. And then it also helps to apportion punishment. You know, all that we have been talking about relating to the other method, we do not talk about punishment. Punishment is another major feature of the adjudication or the adjudication method. So the ultimate desire is to identify the guilty person and to also apportion punishment as appropriate. And then, of course, the punishment in question here is to reorder the life of the individual. To reorder the life of the individual, because it is believed that if the person has stolen and no action is taken at all, the person is probably encouraged to do more tomorrow, isn't it? And then the society becomes unsafe. The society becomes a place where people can do what they like. And then when everybody begins to do what they like, that is anarchy. And then nobody will be able to live and do or have his normal life in such an environment. So, this method works towards identification of the guilty party. And of course, that is to help to formalize the rule of custom that the society, holds there. Because if the society does not punish somebody who has done evil, then what does the society stand for? So you will notice that this particular system of this resolution is different from what we have looked at, on the ground that it focuses on adjudging what is right and wrong, and at the same time provide appropriate punishment that is, put forward to correct or to order the life of the individuals involved in such action. So usually there is room for allowing the offender or the guilty party to also share his own side of the story. So it's not a matter of we are here to determine who is wrong, or we are here to determine the guilty fellow. The system also provides for an avenue for the individual to also share his own story. Because sometimes things may not appear the way they look. So therefore, the system does not rule out the opportunity for that individual to make a case for himself. But eventually, if he's found guilty, the custom of the people will also be made to come to play. So another point you also need to note about this is that the pronouncement of the judicial decision in adjudicatory method, the pronouncement of judicial decisions in adjudicatory method of conflict resolution in this particular on this particular point was determined by the following: pronouncement of the judicial decision in adjudicatory method of conflict resolution was, however, determined by the following. Number one, the character disposition of the adjudicators. That is what helped them to determine the decision in this kind of method. Number one is character disposition of the adjudicators. Number two is the application of customs and norms of the society. May God deliver us from those that are envying us. Hope you can hear my own voice. Ignore the other voice, not for you, to another class. Okay. So, application of the customs and norms of the society is another thing that guides the decision in adjudicatory method. Number three is the manner of probing the truth of the conflict. The manner of probing. Probing is P-R-O-B-I-N-G. Probing the truth of the conflict. Number four is the readiness of the disputants. The readiness of the disputants to develop confidence. The readiness of the disputants to develop confidence in the resulting verdicts is another thing that characterizes the decision-making process under the adjudicatory method. So, therefore, for there to be a decision that is popularly acceptable under this system, the people, the adjudicators involved must be versed in the custom and tradition of the particular location. That is not negotiable. I've spoken about that, several times. So in summary, on this particular method, adjudication method is tailored to peacemaking justice. Okay? It's tailored to what? Peacemaking justice. Which, of course, helps to inaugurate peace and harmony in the society. Because when you prevent a thief from committing the same offense, what you have done is that you are instituting peace and harmony. Because some are in the habit of, if you steal my thing, I will also steal your. But what we are saying here is that this system helps to attain justice in the society. So the last method we are going to look at before we call it a day is reconciliation method. Reconciliation, I think that's the last method I gave to you, right? Okay. Now, when there are issues between parties, the first thing it does is that it brings the relationship, it strains the relationship. For example, if you have a neighbor that you normally go to his house to relax in the evening, and then something happened, the first thing that you stop doing is what? Going to the house. Those that answered appear to have been in that situation before because of the way they answered. So, that is what necessitates the reconciliation method. Of course, there are friends who used to be good friends before, and at the time the friendship got bad, and later on they got into shame, right? Again, due to reconciliation method. Now, Governor Sim Fubara and past Governor Wike, they used to be very good friends. Are we together? It was the friendship that brought Governor Fubara to the position of governor, as I could see from all that has happened. Because Wike believed that, of course, he would have been able to put another person if he didn't want Fubara. But you know, the fights that has ensued between these parties have caused a lot of problem for the Rivers people. But I now understand that they are also trying to what? To settle. I understand that the governor has gone to Abuja to see his master. And then I understand in the course of this week, Sim Fubara also came to Lagos to see Asiwaju himself. And all of this is towards what? To say, Oga, we have finished fighting. And then, of course, when they finish fighting, they will now reconcile and say, let's continue our what? Our business. You know the kind of business that is involved in all of those things. Because if you don't have any vested interest, if you have done your tenure as a governor, you are supposed to leave the state for another person. You understand more than that, so don't let me bother myself too much. So what we are saying is that the need for harmonious living in the society is what necessitates the reconciliation method. Because it's like we said at the beginning that it is not possible that there will be no conflict within the society. So as long as there will be conflicts, resolving these conflicts will be in the best interest of the society and not otherwise. So the background to this system, this method of dispute resolution, is the need to preserve harmony in the community. So then the question then we ask is that, what is reconciliation? Reconciliation is a process of restoring order and normalcy to a hitherto worse situation. Reconciliation is a process of restoring order and normalcy to a hitherto worse situation. Hitherto, I'll spell it. I know it's the spelling that is the issue. All right. HITHERTO. Hitherto worst situation. Worst. WORST. Worst situation. Then it can also mean reaching agreement or compromise towards healing the wounds of misunderstanding. Okay? Reaching agreement or compromise towards healing the wounds of misunderstanding. Towards healing the wounds of misunderstanding. Now let's look at the perspectives of reconciliation method in African society. Perspectives of reconciliation method in African society. As we said earlier, that reconciliation facilitates peace and harmony in any society. And reconciliation recognizes the dynamics of pacification and the soothing medicine. It recognizes the dynamics of pacification, to pacify, and the soothing as in SOOTHING. It recognizes the dynamics of pacification and the soothing medicine for the vexed party. Vexed as in VEXED. Vexed parties to the conflict. I'm sure you know what it is to pacify someone. In Yoruba, what is the word that is usually used when you want to pacify somebody? Yes? There's one I'm waiting to hear. What? Is that what? Mabinu. In Edo, what do you say? Eh? No, the Edo people are denying themselves. You hear Lao, or something like that. So, in the way you also say it also matters. You understand? Oh, ma binu, all those kind of stuff. So, it's as a way of healing what? The wound. You know, you can actually forget what somebody must have done to you. If you really want to forget, it's doable. And then, so, what we are saying is that the reconciliation method recognizes the need to provide that soothing medicine of pacification to the one that has been hurt. So, the party in the reconciliation method must therefore possess the following attributes. Okay? The parties or the third party in the reconciliation method or process must possess the following attributes. So, the person who wants to reconcile must possess the following attributes. Number one, must have the ability to listen. Ability to do what? Number two, capacity for interaction. Capacity for interaction. Number three, must have passion for understanding the issues of the conflict. Must have passion for understanding the issues of the conflict. Okay? Ambiguity is not part of what I gave you. So number one, ability to listen. Number two, capacity for interaction. Number three, passion for understanding the issue of the conflict. Number four, knowledge of customs and norms of the society. Number four, knowledge of customs and norms. Of course, one of the things you will have noticed is that is usually like common in all the methods. Okay. Then number six, Number 5, must have discerning mind for the interpretation of facts. You must have discerning mind to discern. You know, some people can be saying the truth. Some people can be lying and they are saying it with all boldness. Do you know that? Hello, can we have? Must have, I said, must possess the following attributes. And I said number 5, must have discerning mind for the interpretation of facts. Must be able to interpret facts. And part of what is expected in that case is that the person must be able to know who is saying the truth. And the person who is what? Who is lying. Because in some situations, it's not everybody that will always be willing to say the truth. Do you understand? And I know that some people will be telling lies and it will look as if they are saying the truth. Where are those people? Are they here? All right. Number 6, must understand the mood of the parties to the conflict. Must understand the mood of the parties to the conflict. The mood, M-O-O-D. But if you want to spell it in your own, you can say M-U-D. Number 7, readiness to appraise objectively. Readiness to what? Appraise objectively. And last one here is determination to restore peace and harmony. Determination to do what? To restore peace and harmony. So, in the context of reconciliation proceedings, there is no guilty person, no guilty what? Party. Unlike under which method? Good. Unlike under adjudication method. Under reconciliation method, there is no victor nor vanquished. Then, here, the parties are enjoined to give peace a chance. That's one of the paramount attributes of this method. Parties are encouraged to give peace a chance by learning to shift ground and also learn to have the mindset to forget. Forget, forgive, and what? And forget. So meaning that the place of forgiveness and forgetfulness is needed. And in the reconciliation method, parties must be ready to exhibit forgiveness and what? And forgetfulness. Through the following. Number 1, demonstration of apology. I said parties must be willing to exhibit forgiveness and forgetfulness. We are talking about forgive and forget. But we are saying that they must be able to exhibit it, that is, show it through the following. Number 1. Okay, now let me ask you. In what way can or should they show it? 1, apology. That's correct. Write that one as number 1. Yes? Compensation? Yes, hugging each other or embracing it. Because when you say compensation now, it's like a form of punishment too, in a way. But it can also be part of what put hugging each other as another point. Who else? You said what? Public. Yes, you can add that. Yes. Eating together, yes. What? Husband and wife what? Let us talk. Which one is your own? Buying of gift, yes. Yes, I'm with you, Joe. Say what you want to say. You don't want to talk again? She has changed her mind. Yes. What other option? By what?
Showing evidence of joy by smiling.
By showing evidence, you have seen my notes. No, you have seen my notes. This guy, I don't trust him. Because you cannot say exactly what is in my notes. Because I have it here that showing evidence of joy by smiling. Yes, so as somebody was listening out, yes. By admitting, yes, that's also part of it. What? Praying for the offender. Say, I now release you. Go and prosper. Yes. Yes, I think I love that. Like we have all participated in all of that before. Okay, so that's good. So basically, reconciliation method. Is that what? You have said all. You have said all. So basically, all that reconciliation tends to do is that the society must continue in peace and what and harmony. So because reconciliation saves time and energy for the parties, it makes you to channel your energy. Instead of using your energy to beef the other person, you are looking for how the other party will can make it in life. So in conclusion, reconciliation method of conflict resolution, as we have discussed, was anchored on the provision of shooting bands. Was anchored on the provision of shooting ban, BALM, towards promoting peace and harmony in traditional African society. I said it was anchored on the provision of shooting ban, SOOTHING, shooting bands towards promoting peace and harmony where in the traditional African society. So all that we have talked about were the methods, or some, because it's not possible to say that we have exhausted all that they dealt with or that they identified as different methods, but at least majority. And the good thing about the point that we have raised here is that these methods that we discussed that were paramount or deployed during the within the indigenous African society in the time we can call the crude stage of our development is what we now have today. People, instead of going to court now, they embrace arbitration, they embrace mediation, they embrace reconciliation, because all of these methods are actually cheaper than going to court. Because when you go to court, I think the longest case in history that I can remember was a land case that lasted for about 28 years. Yes, Kilode is a good question to ask. So what is the point? It's one adjournment, one reason to adjourn or the other. Parties don't agree. So it can take, and then it's even possible that people that started the case died, their children did what? Took over, and the children are now old. But sometimes there are some battles that may not easily come to an end, especially when it involves communities. Because when one Oba is going, the other fresh one is coming with so much energy and want to continue from where his forefathers stopped. But one of the things we will discover is that when there is reconciliation or they embrace all of this method, it saves them energy, saves time, and there is nothing like peace. There's nothing like peace. All right, so I think we'll stop there for today. Do we have questions? Let me take one or two. Yes. Ask your question. I'll take two. Then we call it a day.